Welcome to Employment Law This Week. I'm George Whipple. Our top story, the NLRB says hand over the telephone numbers. The board's 2015 Quickie election rules require employers to give unions available home and cell phone numbers and personal email addresses for all employees eligible to vote. In this case, an employer did not provide the union with employee phone numbers because it did not maintain them in any formal database or system. The union filed objections after the vote, noting that some supervisors at the company did have phone numbers for certain employees stored in their cell phones. The NLRB ruled that the company had failed to comply with the new election rules. This interpretation shows that employers must provide any and all phone numbers even if they are not actually maintained in the company records. Kat Paterno has more.
This case puts the requirement on the employer to search much more broadly than just their centralized database and actually go out and ask individual supervisors whether or not they have personal information related to each employee that's going to be on the voter list, and then to include that information on the voter list. One best practice would be for employers to start requiring personal information at the hiring stage. However, employers that find themselves served with a petition, the 2 business day requirement, it kicks in rather quickly, but the moment that an employer has the petition in hand or knows the petition is going to be served upon them, the employer should begin gathering this information immediately.
A layoff 6 weeks following medical leave was not an FMLA violation, the Fourth Circuit finds. After returning from medical leave, an employee was assigned to manage a new project in a different division with the same salary and work location. Less than 6 weeks later, the employee and others in his department were laid off. The employee argued that he should have been restored to the exact same position he held before going on leave, and that the termination was retaliatory. The Fourth Circuit held that the FMLA does not require restoring an employee to his or her original position over an equivalent one, and that the employee likely would have been laid off even if he had returned to his original position, due to the employer's financial circumstances. The Supreme Court rules that pension plans established and maintained by some church-affiliated entities remain exempt from ERISA. The Employee Retirement Income Security Act establishes certain requirements for employee benefit plans. So-called church plans are exempt from these requirements. At issue in this case was whether the exemption applied to church-affiliated entities that fund or manage a benefit plan for employees of church or church affiliates. The Supreme Court reversed the lower court, finding that church-affiliated entities are indeed eligible for the exemption. The DOL takes the next step to rescind its amended persuader rule. The Department of Labor is asking for public feedback on its proposal to rescind the so-called persuader rule. The revised rule would have required employers and consultants, including lawyers, to report activity taken in response to union organizing campaigns, including indirect persuader activity. A Texas federal judge issued a permanent injunction halting the rule's implementation last year. The DOL is seeking to rescind the amended rule in order to further analyze whether it would have a chilling effect on employers' rights to seek representation by an attorney. And that brings us to our tip of the week. David Prince, General Counsel and Chief Compliance Officer for Stevens Investment Management Group, is here with some advice for in-house counsel on staying ahead of regulations. We spoke to David at SIFMA in San Diego.
I think the thing with in-house counsel is always be looking ahead at what the proposed regulations are. Get to know your regulators. They're the ones that are going to come in and examine you. Always look at enforcement cases that are coming down and finding out what you're doing at your firm and trying to stay ahead of the regulations.
Thanks, David. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.